Hey everyone, Sean here. Earlier I promised a tighter dive into the preliminary injunction motion filed by the plaintiffs in the Shutdown RIF case. So first, the big picture. Plaintiffs want the court to convert the current TRO into preliminary injunction that lasts through the case. They're also asking the judge to rescind the Shutdown RIF notices issued on October 10th and require agencies to send rescission letters to employees. They further ask for sworn compliance reports so the court sees proof, not promises. Here's what they're saying in detail. 1, the legal premise is wrong. A lapse in appropriations does not erase an agency's statutory authority to employ its workforce. Treating a shutdown as a green light for mass RIFs rests on that error. If the premise fails, the actions that followed are unlawful under the Administrative Procedures Act. 2, the decision-making was arbitrary and capricious, right? The record shows rush, inconsistency in statements suggesting political targeting of programs. Agencies lacked reasoned analysis. That's the classic APA problem. Action without a rational, evidence-based basis. 3, the process was chaotic, and the government did not comply with the TRO cleanly. Employees and unions struggled to get basic information about which programs, projects, and activities, the PPAs, were targeted. In some places, the RIF clock kept running after the court told agencies to stop. Because of that, plaintiffs request structured compliance, quick accounting of any RIFs issued or prepared since October 1st, a standard rescission letter for each affected employee, and sworn declarations confirming delivery. 4th, the motion invokes 5 U.S.C. Section 705. The statute lets the court stay agency action to preserve the status quo. Here, status quo means the workforce before shutdown RIFs begin. A stay works alongside an injunction to ensure nothing sneaks through during litigation. 5, irreparable harm is immediate beyond lost pay. Employees face health coverage disruptions, retirement timing problems, and the inability to get HR guidance while furloughed. Anxiety and career damage cannot be fixed by money. New declarations expand the harm record. 6, equities and public interest favor relief. Preserving the status quo does not harm government, and there is no public interest in continuing unlawful action. The public benefits when agencies follow the law and employees are not whipsawed during a shutdown. So who is protected now? The order entered yesterday expands coverage to NTEU, IFPTE, and AFT alongside with AFGE, AFSCME, NFFE, SEIU, and NAGE. Protection follows the PPA wherever those unions have members, including unions the government recently tried to derecognize. The covered agencies list is broad, spanning most major departments and independent agencies. What the order requires in practice, so no new shutdown-driven RIF notices and covered PPAs, no steps to implement the October 10th notices, no counting days towards effective dates. The clock is told and employees cannot be required to perform work that advances those RIFs. What you should do now. If you received an October 10th RIF notice, your notice period should not be running. If you are in a covered PPA, you should not receive a new shutdown RIF. Document inconsistencies with the order and share it with your steward. Consider consulting counsel if you're ready to litigate, or otherwise as you prefer. Bottom line, the motion asks the court to turn, pause the protection, undo the October notices, and require verifiable compliance. We'll keep translating the filings as they land so you can focus on your family, your health, and your work when the government reopens. Thank you everybody for your support. Take care and have a great day.